Good morning, Your Honors. William Shellhart, Office of the Attorney General, appearing on behalf of the appellant, the state of Florida. I would like to reserve 5 minutes for any rebuttal argument. Your Honor, we're here. It is a state appeal of a trial court's order granting a motion to suppress evidence after a Franks hearing. It is the state's position that the trial court did not consider the totality or in toto the controlled call between the appellee and his girlfriend at the time, and instead required a much stricter verbatim type recounting of Mr. Domenich's statements from the controlled call rather than the summary which the detective provided to the court.
You would have had a better shot if you had just verbatim quoted the transcript.
Your Honor, unfortunately, this was a control call. It's not an interrogation. It's not, you're not going to get the, I admit that I have images and videos of child pornography on my laptop and USB drive. And by child pornography, I mean images and videos of young girls under the age of 18 engaged in sexual conduct. And by sexual conduct, I mean that. So this is a conversation between two real human beings that are not lawyers, that it is a conversation between a boyfriend who is trying to salvage his relationship with his girlfriend. And if you look at the totality of the call.
Well, the detective, though, this is in his wheelhouse, and the things that make their way into the affidavit are things like the Tor browser, which that's different than what the defendant didn't say anything about using a Tor browser, did he?
He did not say anything about using a Tor browser, but if you look at the probable cause affidavit attached to the search warrant, the detective makes clear on page, I think it is, let me say, it is 4 and 5. So that's record 204 and 205 of the search warrant affidavit. He discusses that in order to access the dark web, you do need to use a Tor browser.
So your position on that is it can be inferred, and the Tor browser is mentioned elsewhere in the controlled call.
The dark web was mentioned in the control call. The ability to access the dark web with the use of a Tor browser was mentioned in the search warrant affidavit. There are other things.
Tor browser was not itself wasn't mentioned on the call.
It was not. The words Tor browser did not come out of appellee's mouth in the control call.
At the very bottom of it, your case is that if we excise the offending, the references from the affidavit that are complained about, right, then there's still enough in the affidavit for probable cause, reduced to simple terms. That's
yes, Your Honor. It's the state's position that the trial court erred by excluding this entire portion of the search warrant affidavit that discusses the controlled call. We know from Franks and Johnson and other cases out of this court that what you have to do is you have to look at the problematic statements.
so, for example, using your model for this, the part of the affidavit that talks about the Tor browser would say downloading various photographs and videos from the dark web to include images and videos of child pornography.
And yes, Your Honor, that's
what's
probable
left,
cause,
right?
Yes, and it's the state's position that
Probable cause, just using that one part.
Where in the control call did he confess to downloading from the dark web or not, or with the Tor browser or not, images and videos of child pornography?
So again, the control call is 26 minutes. And if you look at the control call,
here's your opportunity to tell us where in the control call he confessed, because Judge LeBrit said, well, the excise the portions that talk about the dark web and Tor browser, which is there not mentioned. The dark web was mentioned with regard to getting Cialis. The Tor browser is not mentioned at all. But you're now saying that yes, we could in our analysis. We could analyze probable cause, including the statement confessed to include images of videos of child pornography, confessed to doing that. So yes. Where is that?
So again, if you look at page 5, I'm going off my brief because I have a summary of the relevant portions of the control call there. Again, this is appellee, you know, that specific material, and they're talking about, again, 3 paragraphs earlier, sometimes, you know, it's young girls. And then down, you know, that specific material is not something that you're going to find on the open internet, you know, And then she talks about, when did you first get these applications? And that's when he starts talking about, I originally got them because I wanted to buy these medications off the dark web. So is there a complete sentence where appellee says, I downloaded images of child pornography from the dark web? No, but gleaning from the conversation, and again, you can't look at just, it's the state's position that it's inappropriate to just look at individual sentences to glean the meaning of what was in the search warrant affidavit. You have to look at the call in total. He talks about it's
But if the detective is saying that there's child pornography downloaded, is that enough? Isn't he going to have to describe what he means by child pornography?
so
I've seen some cases where that is a requirement.
So again, the detective in the search warrant affidavit, I'm going to page 1, so it's record 201. For purposes of this affidavit, the term child pornography refers to that term as it is used in Florida statute 847.001 and children engaged in sexual conduct as it is used in Florida statute 827.071. So the detective does provide those
It
definitions.
doesn't say child pornography in the call.
Correct, because normal people, lay people have.
So let me piece together what you said, because at some point he said he looked at young girls on the internet, and another part of the call, he said he used the dark web to download, to purchase Cialis. Let me look at it a different way, and tell me whether you think this is consistent with case law. So I understand what you're piecing together, a couple of different portions of the call to posit that that he did in essence confess to downloading images and videos of child pornography. But could that be a problem if I look at case law and perhaps other courts have looked at the applicable standard in a different way? In other words, don't you have to throw out that whole sentence wholesale? Because if we don't buy your argument that confessed to include images and videos of child pornography is not a falsehood, then you have to throw out that whole statement and try to rely on other things in the affidavit. In other words, why should we consider any of that statement?
Okay, so then we get into what is the definition?
It's a lie.
It is not a lie. I mean, if we want to get into the words, what does the word confession mean? Okay, he acknowledged that he downloaded images of child pornography. Is that the same thing?
Well, okay, try to not include the false parts and say he acknowledged what? He acknowledged that.
He acknowledged that he downloaded images of young girls between the ages of 10 and 17.
No, okay, let's go there. So where does it say between the ages of 10 and 13?
Okay,
And
so again,
is there anywhere where the affiant told the magistrate what age the defendant's children were?
that was not in the search
Is that
warrant.
extraneous to the affidavit in the search warrant?
Again, a search warrant is not presenting an issuing magistrate the entirety.
What's the standard? And the standard is if you excise the false parts, is there still probable cause? So how can you import stuff that wasn't even in there to essentially, I didn't even really understand it at any given point, the state's argument, whether you're saying it wasn't false at all, whether you're saying it wasn't reckless, or whether you're saying, well, we can cobble some things together and still have probable cause. Because my understanding of the case law is you have to excise, for instance, that entire sentence that says he confessed that he had downloaded various photographs and photos from the dark web using a Tor browser to include images and videos of child pornography because it is false.
All right, I'm going to try to answer the court's questions that I remember. And so if we're looking at page 12 of my brief, and I apologize, I'm not sure where it's in the control call. And then the girlfriend says, and you don't even want to guess at the age of the girls, but her. And then appellee says, I mean, I would imagine they're like around Taylor and Jonah's age, you know. The girlfriend, so 11, 13, appellee, yes, 10 to 16, 10 to 17, you know. So that's where we get, these are images of children between the ages of 10 and 17. What the state's position was that a Frank's hearing was not even required here because the threshold had not been met. So that was the first part of the argument in my brief, was that in order to even get to a hearing, there has to be some demonstrated falsity of the statements contained in the affidavit. And the state's position is that when you look at the entirety of the control call, You look at the allegations in the search warrant affidavit, it's not materially false in there. Are there summaries?
Reckless, it was a reckless disregard, part of the standard met when a sworn law enforcement officer says he confessed to downloading child porn. You're saying no, because in a manner of speaking, he confessed to downloading images, and then you'd have to link it up with the pornography part, right?
It is
Because you have to link it up to the part where he's saying, where the images of children of that age, although obliquely that information might be inferred, was pornographic.
Yes, sir. And on page, again, 13 of my brief, and I apologize, it's the control call, girlfriend. Okay, and you don't want me to open these videos? Like, what are they doing in these videos? Helly, nothing. I mean, you know, typically sex or something, you know, or sometimes it's just girls dancing around. Girlfriend. So is it adult male with a young? Appellee, some of them are adult male with a young girl. Some of them are, you know, two younger people. So again, it is the state's position that a rational, complete reading of this controlled call supports the factual statements contained in the search warrant affidavit.
So would you agree? I'm sure you wouldn't, but I'll ask it anyway. If we took the meaning that I was positing for the sake of this discussion today, that you'd have to throw out wholesale any of the statements, if the members of this court were to agree that they met the standard of reckless disregard, you know, you'd have nothing left. But you're saying that, so are you hanging your hat on the first essentially prong of the analysis to say that these statements they don't meet the definition of reckless disregard?
Absolutely not, Your Honor. Again, I addressed that in my brief. And again, it's the state's position that a Franks hearing wasn't even warranted in this case, but we ended up with a Franks hearing. So then we look at reckless disregard. And I know this is going to sound very lawyerly, but the truth that we're looking for when we're talking about reckless disregard is not factual truth. It is the affiant's belief in what he is writing down as true.
Is that sort of like the prophylactic purpose of the Fourth Amendment suppression coming through there? Is that the reason for that? In other words, it's not that we're trying to make sure that why is it the state of mind of the affiant?
So when we talk about the exclusionary rule, we're doing it to try to curb bad police behavior. We want it to be a lesson. We want the police to know that if they lie in an affidavit, if they make up probable cause, if they make up a control call out of whole cloth, which is not the situation we have here, that we're going to hold them to account and we're going to suppress all the evidence that they find as a result of their lying. Here, when we're talking about the affiant's belief in what he is writing down, there's no bad faith there. There's nothing to correct.
What if we took the opposite position? So going back to what seems to be top of my mind is what we need to excise and what we don't. What if I took the position that was reckless disregard? To have cobbled together various statements, even if you're correct that a reasonable listener could have inferred that he was downloading child pornography, that it was just reckless disregard to affirm to the magistrate that he had quote unquote confessed to quote unquote downloading quote unquote images and videos of child pornography. What if we would get that? Where did your argument go down?
Your Honor, if you want to take, again, I think that's the problem that the trial court did. It was looking for quotations. It wants.
Well, I don't think my perception is unreasonable. It was an officer who tells a magistrate that a suspect has confessed to downloading images and videos of child pornography. He treated the truth with reckless disregard. So if I take that view, where does your argument go? What's your fallback?
Then that is the position of the trial court, and the state would disagree with Your Honor's
holding.
holding.
That statement gets excised.
Yes.
Okay, so that statement, okay.
Again, it's the state's position that it's inappropriate to look at it for this verbatim.
Going back to my original thing, so yes, you could draw an inference cobbled together other statements, which is reasonable, but even if I took your point that it's reasonable to draw the inference that he did something akin to confession, if this court decides that it was that officer in putting that statement in the affidavit acted with reckless disregard, then we must excise it in our analysis of whether the remaining portions constitute probable cause.
That is a legal test, yes.
Mr. Shellhart.
Yes, sir.
You're up to 15 minutes.
I will reserve my remaining 5 minutes for rebuttal. Thank you, Your Honor.
Mr. Weisbrod.
Good morning. May it please the court, my name is David Weisbrod and I represent appellee Jason Dominich. If I were to swear out an affidavit to any judge in any county in this district, any judge in this state, any judge anywhere, where I said that the target of a search had confessed.
Wait a minute. Let's talk about what confessed means. This guy starts off in the controlled call by saying he struggles with porn and apologizing to the girl, to his
Girlfriend.
partner. And then when she says, how long have you been, looking at these underage girls? He says, I don't know, like I said, I haven't been looking for a long time since we've been together, but it happened gradually over these years. So he's admitting, which is, to my understanding of the definition of confess, a synonym to confess. He's admitting this, and then he takes her through it with the ages, or the Tor browser, definitely, we get that. I think the test in the case law is to excise the material, not the entire sentence. So we change, view confess as a synonym for admit, and all we lost here is a Tor browser, because he's definitely admitted downloading the images, and he has indicated that he's looking at girls and children between the ages of 10 and 17 who are engaged in sex acts. Which part of that isn't consistent with, for example, the PCA's decision in Rome?
Because the affidavit says he's investigating a violation of Florida statute 827.071, which is sexual performance by a child, by a minor. This is in 2021. That's what the offense was. There is no admission during the course of the controlled call to downloading and possessing images or videos or any depiction of a minor engaged in sexual conduct.
You mean the part where he says sometimes they were dancing, sometimes it was solo, sometimes it was with an adult male? That's not a performance?
Well, it has to be sexual conduct. Sexual conduct has a very specific definition in 827.071.
Well, he starts out by saying, typically sex or something, or sometimes it's just girls dancing around. And some of them, he's answering the question, is it adult male with a young? Some of them are adult males with a young girl. Some of them are, two younger people. Which part of that is not within the generally understood meaning of the statute?
Because young could mean old, and young can
In the
have.
context of this call, young clearly means underage.
But not necessarily during the entirety of the conversation, because he talks about struggling with porn generally. When he talks about an adult male with a young girl, it's not necessarily in that age group, and it's not within a sexual performance.
So we should read young girl in an entirely context-free manner in this transcript.
No, I don't think it has to be context-free, but I think it has to be, if it's going to be an admission, it has to be more than putting together inferences, which, by the way, were not part of the affidavit presented to the.
How is it not part of the affidavit to say they were 10 to 13 when those words were spoken by the girlfriend, and he affirmed that yes, he even, and then he went on to say 10 to 17 or 10 to 16. What is not? I don't want to commandeer the conversation.
No, please.
Anyway, I just can't help it. But I think it is along the lines of what Joe's been saying though, even if I personally would say that that first statement I focused on earlier, reckless disregard, how is the statement that the images were of adults engaging in sexual activity with young children, and then the ages were actually discussed by the participant phone call? Is it just the quotation marks around young children? What if we just excise that word young children, since he didn't really say young children, and then we just said, well, their ages of 10 to 13 and there was sexual activity? He said those things, right?
Well, no, because when this is the second portion of the probable cause statement that was addressed in both the briefs and at the hearing. He stated the images and videos were of adults engaging in sexual activity with what he described as, quote, young children. So yes, the representation by the detective is that appellee said the words young children.
Oh, we'll take that out. And
All
then
right, so that's
that
not
sentence-
right.
And then what does that, how does that sentence read? How's it false if you take out
Well,
the word young children?
None of it is stated because he also didn't say children engaged in sexual activity with other children. That's not in the call. Children in solo performance, the detective admitted at the hearing he made that up. And when he was asked on cross-examination, why did you include it? And he said, well, I wanted to show it as the totality. It didn't necessarily have any sexual connotation to it. So he's putting into the affidavit to the magistrate something that didn't happen to show it's part of the totality, which doesn't make any sense. That's internally inconsistent. And he then says,
What
well,
about dancing around? Is that a solo performance?
I don't know what, I guess that's part of the problem is what does that mean? And if it has the meaning,
What if you excise dancing around and young children? Now what portion of that sentence is wrong? When there was discussion of sexual activity and there was discussion of the age of the participants in the sexual activity.
well, again, it's the way he put it in the affidavit. And the statement in the affidavit was he stated, meaning Mr. Dominich stated that the images and videos were of adults engaging in sexual activity with what he described as young children, comma, children engaging in sexual activity with other children, and children in solo performance, all between the ages of 10 and 13. That's just not a
What if we
fair
take
reading.
out 10 and 13? Because he said 10 to 17, which is still within the meaning of the statute.
Well, then you also have to take out solo performance because he admitted he made that up. You have to take out young children because that's in quotes and that wasn't stated.
Well, he said some of the videos captured images of adult males with a young girl. And that's in response to the question by the partner about how long have you been looking at these images of, underage people, the age of my children, is essentially what she's asking.
But again, that's not in the affidavit for starters. So the magistrate didn't have access to that. And number two, it still is piling an inference on. There's no reference to sexual conduct.
Of course there is, adult males with young girls.
But they
And
could-
she's asking him.
But there's also,
Typically sex. He says nothing. I mean, typically sex or something. Sometimes it's just young girls dancing around. Some of them are adult males with a young girl. Which part of that should we excise? That's in the controlled call.
it's in the controlled call, but it's presented improperly to the magistrate when in this second portion of the probable cause, if he had said this, would that be enough? If he had quoted the recorded call, would that be enough? My argument would still be no. But
You don't think the transcript of the controlled call is enough?
no, ma'am, because again, it's the statute being investigated is possessing a photograph, including sexual conduct by a child, engaging in actual or simulated sexual intercourse. And I think that requires a little bit more specificity than what's in the
What
call.
cases do you have is there any cases where, there's, very unfortunately, there are a lot of child porn cases, and fortunately for us, we know that there are too many, right? But so what do you, is there a case law where you can point to that an affidavit, warrant affidavit that didn't specifically say sexual intercourse was somehow deemed not probable cause to believe that these images of children in sexual contexts was violative of the statute, that there was not a reasonable reason to believe that that could have been occurring?
We did cite a federal case for you where an officer had misrepresented what he had seen in a photograph in obtaining a warrant, and how his view of what was obscene versus what was in this photograph were two different things and a misrepresentation of the facts. And that's just the closest I got.
Well, that's him looking at the image. So that's it. Okay, so that's him looking at the image and misconstruing what the image was. Here, the affiant is doing something different. The affiant is relating the contents of a conversation. So you have, that's maybe a good analogy, but that doesn't answer my question, which is in a warrant affidavit for a search warrant in a child pornography case, does the officer, if you have to, lay out the exact depictions, the details of the depictions? Here, the officer admittedly didn't know what they were. That's why he wants the warrant. He wants to go in the computer.
Right. So, well, he knows he doesn't have probable cause before the call. So the entire purpose of conducting the call is trying to obtain probable cause. And that would be to then be able to describe to the court, I think, at least with some detail, exactly what these images might be. And
Just saying it was sexual activity. If you take, for the sake of discussion, I'm not conceding this, that the inference could be drawn that children between the ages of 10 and 17 were depicted in these images engaging in sexual activity. If you take, for the sake of discussion, that's a fair inference, and that was not a statement made with reckless disregard for truth, then that you're saying is not enough, because the officer needed someone, CI or the defendant to say, oh, it was sexual intercourse.
no, I think you have to meet the definition of the statute, which is actual or simulated sexual intercourse. And so in your example, if he had said that there were children engaged, if on the tape he had said children engaged in sexual intercourse, then
No, sexual activity, because I know he didn't say intercourse. My point is, if he does say sex or stuff and stuff, but sex, I'll look it up, sex, and we all know what it says.
typically sex or something.
Sex or something.
Or
You're
something.
saying that categorically is not enough in a probable cause in a warrant affidavit. If an officer said, I have a CI that said, I saw my husband had pictures of kids doing sex and stuff on his computer, that's not enough?
Well, the last part of that seems like it would be enough, but the front part of it, I
I'm
don't.
trying to parse your argument. Is it
No.
because he needs to depict, he needs to describe in detail what the type of sex statute is considered?
He has to accurately describe what was said on the call, and then does that then rise to the level of the statutory definition of sexual performance by a child? And
Put in a different way, it's not that he has to accurately recite the pins and needles of the call, it's that he's obligated not to do it with reckless disregard for the truth or the other part of the standard. Essentially, the idea that he was required somehow to spell out every last nut and bolt in this call, because one that's been around and rejected
no,
by case law.
I'm not suggesting that. I don't think I'm suggesting that. I think I'm suggesting that he just had to do what we would consider to be a normal job. The transcript is not that long. The call is not that long. You, as the investigating officer in this case, are counting on the content of this call to sway a magistrate to issue a warrant. Fair enough. I think then you have an obligation to be careful with what was said on that call. And he said during the Franks hearing that it would be an undue burden and too cumbersome for him to have been able to go through the call and repeat things. We can say verbatim, but really it's accurately, because we know it's not particularly accurate. And He has support staff at a law enforcement agency. He himself could have listened to this. If you know, he listened to the call when it was happening. If he believes that there were points in that call where Mr. Dominant said
So
things that
reduced to simple
implicated-
terms, your position is, it necessarily has to be, that what this officer did rose to the level of hoodwinking, bilking, or duping this judge into issuing the warrant.
the actual term from Franks is deception.
Actually, I'm reading what the fourth district has described the Frank's test to mean, and we're here in Florida, so I think that's pretty good law.
Well, and I think the Florida Supreme Court and Thorpe and Terry, the other district courts of appeal and Pagan, and I think that the basis of the reckless disregard is not communicating accurately and deceiving
Actually,
the magistrate.
Frank's requires a willful misrepresentation, for lack of a better succinct term.
Well,
And-
reckless disregard. It's not intentional, although the circuit judge came pretty close to intentional when she first said this was a lie in reviewing the affidavit. And then she said, I don't want to say that, it's a misrepresentation of reality. She backed off the lie, although later she said that she characterized it as BS. Because with her experience having issued warrants, when she sees words like confessed and stated in this context, the analysis is almost over at that juncture for an issuing magistrate.
That leads to something that has come to my mind about going back to the standard. So, what if I were to agree with you that the statement regarding his confession to having downloaded images of child pornography on the dark web or browser met the definition of hoodwinking, bilking, or duping, or as you said, deception, which pick your standard. And isn't that analysis per statement? In other words, of saying this is, this is not the purpose of this Frank's analysis is not to send a message, solely to send a message, is to balance sending that message, a deterrent effect of law enforcement, with the needs of law enforcement, which is to perform investigation. So if I were to apply that standard and say bilking, duping, deceiving, met the standard for that one statement, but it did not meet the standard for another statement, which standing alone would constitute probable cause, doesn't this need to be reversed?
Well, your hypothetical sets it up as though it would need to be reversed, because then you're accepting.
No, I know you're not going to concede that,
Right.
you know, because that you don't have some other way to perceive it. But my point is, you keep making statements that sound like we have to read this affidavit wholesale. And even if I agreed with you that, in other words, go to the statement you said, the circuit court made a cogent point, which is, you know, if a magistrate hears he confessed to the crime, it's largely over. And that's a good argument. That's a good argument, I think. But does it conform with Frank's, which says that statement might be excised, but there's still probable cause in other statement?
Oh, well, I think the court went through, though, each of the 5 statements that constituted the probable cause. So at the Frank's hearing, counsel was very careful to go through the entirety of the affidavit with the detective to find out, or to get him to acknowledge, which parts constituted the probable cause and which would make the background.
What the trial court did. The trial court is charged with giving great deference to focus and to focus the inquiry on based on the totality of the circumstances. And is that consistent with the pronouncement from the Supreme Court that, you know, a begrudging attitude on these affidavits is not what we're aiming for here, given the underlying purpose of the First Amendment, or at least one of them, which is to encourage warrant searches, not warrantless searches.
But she did, because I believe what the circuit court did was she went through each of those 5 probable cause statements within the affidavit, the only 5 that really could count toward probable cause. And she reviewed them in connection with the transcript of the call, and she found them to be inaccurate. And she also found that the detective wasn't a particularly good witness. She went off on a tangent toward the end about why he wasn't believable due to some other statements he had made. And frankly, just didn't accept the notion that For instance, the detective said as to one of the statements, well, that was a misstatement and not a mistake because he intentionally put it in there. He doesn't want to say that it was a mistake. It's a misstatement. Well, that doesn't help because that's a false statement. And that's the one, the fifth statement of probable cause where he put in the affidavit, Dominic stated he never engaged in any inappropriate contact with Russo's daughter, but has been engaging in viewing child pornography ever since he was exposed to it in college. Everything after the word daughter in that statement does not appear in the controlled call. So the trial judge went through each of these five one by one, and then she did conduct an analysis as to whether or not there was probable cause, came to the conclusion there wasn't, and the state below didn't lay out with any specificity or particularity what the probable cause at that juncture might have been. And in fact, they haven't done so here. It was just a conclusory statement in their initial brief.
So what's our obligation? What's the standard of review of the analysis, the second prong? I don't know if that's how others describe it, of Frank's.
Mr. Whiteford, let me interrupt you. Your time is up, but please answer this question.
Well, generally speaking, in the context of the order of the circuit court, whether or not there's competent and substantial evidence to support their finding as to the probable cause, whether or not de novo review, there does exist within the four corners of the affidavit, not necessarily all the extraneous extras in the recorded call that were not provided to the magistrate, and whether or not that arises to probable cause. And I believe the trial court correctly performed that analysis.
Thank you, sir.
Thank you.
Michelle Hart.
Let me ask you a question right off the bat. To what extent is the trial judge's credibility determination concerning this officer even relevant to our review?
Your Honor, because it's a de novo review, I don't know that her belief about the credibility of Detective Hatch is relevant to this court's discussion. This court has the chance anew to look at the control call transcript, compare it to the search warrant affidavit, look at how the trial court analyzed that, and decide if the trial court's reasoning is supported by competent substantial
So
evidence.
essentially, under your lights, the answer is review the affidavit against the transcript, excise whatever is unsupported, and determine whether probable cause would be made out.
Yes, Your
without
Honor.
The excise material.
Well, the process calls for a hearing, right? So it is, and the standard is deception, duping, et cetera. And so there's nothing about the credibility of the witness that can or can't be considered by the trial court, and to which we have a deference about whether this officer acted with reckless disregard.
Your Honor, I'm not aware of any case discussing Franks that talks about the credibility of the witness. I think the reason for the hearing is just the shifting in the burden. In order to obtain the hearing, I think the language is there has to be a substantial showing of
Does it even
fault.
say, did Kessler even say it has to be evidentiary, or is it just a hearing?
Again, it's not entirely clear, but it's substantial showing, and then the burden, that's to get the hearing, and that at the hearing, then it's preponderance of the evidence. So I guess that's the reason for the hearing. I know my fellow counsel here has described the statements not contained in the search warrant affidavit, the four corners of the search warrant affidavit is extraneous. Again, I believe those statements from the control call are one, relevant to the determination whether there are false statements in the search warrant affidavit, and then two, it's relevant to the determination whether Detective Hatch was trying to hoodwink or lie to the issuing magistrate.
So
And
the evidence then that's considered at the Franks hearing is whatever evidence the officer is relying on to support the statements in the affidavit, as opposed to the evidence of the officer testifying reconstructively.
And again, Your Honor, I searched high and low for a bunch of case law to try to figure out like what is the purpose of the Franks hearing and how it should be conducted. And it's
I mean, it is referred to as an evidentiary hearing. throughout the jurisprudence.
But I think it's just the shifting of the burden of proof from substantial to preponderance.
What about the Emily's suggestion that the state has not taken the time to piece together what probable cause would be if any of these individual statements were deemed to be excisable on account of their reckless disregard of the truth?
I believe I addressed that in my brief. I think I agreed that at a minimum, the Tor browser comment should come out, and then comment perhaps about he's been watching it since college. I know there's a reference. He first watched it in college, but then it was only the past 5 or 6 years that it got really bad. So I think I did agree to excise those statements, and that it is the state's position that even excising those statements, that there still remains a probable cause. Your Honor, we believe that the trial court had an unreasonable reading of the search warrant affidavit as compared to the control call. If you look at the control call in its entirety, we believe that the factual recitations contained in the search warrant affidavit were by and large supported by the contents of the control call. Even if this court deems that they were not, there is no evidence that the detective was attempting to do the issuing magistrate. He did not make up this controlled call out of thin air. It actually happened, and to the best of his ability, he wrote what he believed the control call said in that search warrant affidavit. So unless there are any further questions, I will yield the rest of my time. I would rely on the arguments contained in my brief, and I would ask this court to reverse the trial court's order suppressing the child porn found on Appellee's laptop and USB thumb drive.
Thank you, Mr. Shelfart. Thank you both. I'm going to refer to our next cases, the DeGrasse Field cases.